This is Dr. Mark Leiser. I've decided to do a series of 5 lectures on why I think the digital omnibus is so important. This is the fourth of those 5 lectures. One useful project can meet several European rulebooks at once. Uncertainty at each boundary does not merely add paperwork, it multiplies. We will follow an illustrative rare disease study, Project Atlas, from a participant's browser to hospitals, researchers, and a controlled data space. 4 questions recur. May the portal access the device? May health data be reused? Who can identify the records? And which database rules apply? The Omnibus can make those questions line up. Project Atlas is illustrative. It's not a real project. It studies a rare condition for which no single hospital has enough cases. A participant opens the project's web portal. The portal remembers a language choice, protects the login, and measures whether its pages work. It does not need a behavioral advertising profile. Hospitals in several member states contribute health records. They replace direct identifiers with codes and keep the identity keys. Researchers seek to reuse the records for a question about early diagnosis. They work inside a controlled data space where downloads and re-identification are restricted. The public interest case and the safeguards look strong, yet the project must ask, is device access permitted? Does each hospital have a route for secondary research? Are the records personal data for every recipient? What does the European Health Data Space add? The overlap decides whether the project proceeds. Project Atlas passes through 4 gates. Gate 1 protects the participant's device. Gate 2 governs research reuse. Gate 3 asks whether a particular actor can identify a person. Gate 4 governs analysis inside European's data space framework. Each gate performs a different job. A lawful answer at one gate is not a passport through the others. A permitted security cookie does not settle the latter use of personal data. A research permit does not make a dataset anonymous. A secure data space does not itself answer every GDPR question. The difficulty appears when each answer remains slightly unstable. Lawyers have to repeat classification work. Engineers have to build for the strictest possible reading. And partners wait for one another. Delay at one gate spreads across the project. This is the friction multiplier. Several defensible safeguards, several overlapping regimes, but no clear sequence connecting them. Start with the portal. Terminal equipment simply means the participant's phone, tablet, or computer. Article 5.3 of the ePrivacy Directive protects storage of information on that device and access to information already there. The important word is information. The rule does not wait for the information to become personal data. In Planet 49, the court confirmed that active consent matters and the personal or non-personal character of the information does not decide whether Article 5.3 applies. The debate is therefore much broader than cookies. A security token, local storage instruction, tracking pixel, or device identifier may fall within the trigger. That breadth protects the user's private sphere, but can place low-risk operations behind a consent banner unless exemptions are clear. For Project Atlas, device access is the first question. Personal data comes later. A coherent system asks 2 questions in sequence. First, was storing or accessing information on the device permitted? It may be strictly necessary, covered by a clear exemption, or based on consent. That is the ePrivacy question. Second, what happens after the information leaves the device? If an actor processes information about an identified or identifiable person, the GDPR supplies the lawful basis, transparency, minimization, and rights framework. If the information is not personal for that actor, those GDPR duties do not arise merely because the device rule applied earlier. Consent to one device operation does not automatically authorize every latter purpose. Equally, a GDPR lawful basis does not bypass device protection. In Project Atlas, a short-lived security identifier raises the first question. Combining portal activity with participant record raises the second. Keeping them separate avoids duplicated consent and regulatory gaps. My report therefore argues for a purpose-based low-risk whitelist. The law should ask why the device is being accessed, not simply which technology performs the task. A narrow exemption can cover transmission and a function explicitly requested by the user. Security and authentication. service or transaction fraud prevention, tightly constrained audience measurement and analytics, and limited first-party functions that do not follow a person across services. For Project Atlas, that could include protecting the login and counting whether an information page loads correctly. Each exemption needs guardrails, a defined purpose, short retention, restricted access, limited combination, and no repurposing for behavioral advertising. Measurement by a provider's processor should not become independent tracking. Cross-service profiling, data broker linkage, and behavioral targeting should remain on the consent route. This approach does not weaken choice. It removes low-value banners from routine, bounded functions so that consent appears where a decision is genuinely meaningful. Removing unnecessary banners is only half an answer. A person should also be able to express a device access preference once and have services recognize it. A broad refusal can travel across services because saying no does not authorize anyone to act. A valid yes is harder. It must identify enough about the controller, the purpose, and the scope of the choice. One global yes cannot sensibly authorize every embedded company and every future use. A browser or operating system can carry a reusable signal, while a consent receipt records what I don't want this. Now move from the portal to the hospital records. Secondary use means using data collected for one reason, such as patient care, for a later research question. European law permits important research routes, but member states still make different choices about legal bases, special category data, and safeguards. That fragmentation can produce three answers from three hospitals. One partner may use a statutory route, another may need fresh consent, a third may require a different transparency process. The consortium then designs several versions of one study, narrows the cohort, or abandons the cross-border element. Rare disease research depends on scale because each country may have few cases. Consent can also be fragile when people cannot be recontacted or a new question emerges years later. The European health data space raises the stakes. It aims to support secure secondary use of health data. That infrastructure cannot reach its potential if the underlying research route changes whenever a border is crossed. The Omnibus moves in the right direction by clarifying 3 points. Scientific research may pursue a legitimate interest. Later research can be compatible with the original purpose, and in defined circumstances, providing individual information may be excused where it would require disproportionate effort. That is not blanket permission. Ordinary personal data still needs a lawful basis. Health data still needs an Article 9 condition. Article 89 safeguards still matter. Project Atlas should minimize data, separate identity keys, control access, document purpose, and prevent unsupported onward use. The root must be operative and harmonized. A recital can explain a rule, but cannot reliably replace one. Binding text should say when a pathway exists and which minimum safeguards travel across borders. That stops research becoming camouflage for ordinary commercial processing, while preventing genuine safeguarded research from being redesigned around the Union's most restrictive, uncertain interpretation. The third gate returns to the question from Lecture 2. Personal data for whom? Pseudonymization means replacing direct identifiers while keeping additional information, such as a key, separately. The hospital keeps the key, so the records remain personal data for them. A researcher inside the controlled environment may be different. With no key, no lawful route to it, and no realistic matching data, identification may be not reasonably likely for that actor. The conclusion depends on evidence. The access design, contractual restrictions, available auxiliary data, monitoring, output controls, and foreseeable onward transfer. It's not a permanent anonymity label attached to the file. If the researcher gains new linkage means or exports the records into an uncontrolled environment, the assessment changes. A secure data space is valuable because it can be capability reduction real. The Omnibus should make the legal effect of that architecture legible, while keeping responsibility with any actor that can still identify a person. This leads to the fourth gate. The definition of personal data in Article 4 acts as a switching rule across Europe's digital laws. A switching rule decides which additional legal layer applies to an activity. In the European health data space, the answer affects how permits, secure environments, and anonymization requirements interact with the full GDPR. Under the Data Act, it affects whether access and portability duties operate alongside data protection limits. Across common European data shapes, it shapes contracting, share, and reuse. AI training is an adjacent example. The AI Act still governs lifecycle risks, while the GDPR overlay depends on whether training data are personal for that actor. Each law has its own job. Real datasets mix personal, non-personal, pseudonymized, and aggregated elements. Project Atlas should not restart the same status argument under every instrument. A clear Article 4 assessment, supported by a portable assurance record, should travel with the defined environment unless facts change. We can now see the multiplier. Uncertainty about device access meets national variation in research law. That meets an unstable identifiability threshold. The result then enters a data space whose access rules depend on the same threshold. Each unresolved question changes what follows. The portal displays more banners. Hospitals demand different agreements. Researchers treat every record as personal for every actor. The database operator repeats checks already performed elsewhere. The costs include delayed contracting, duplicated governance, smaller samples, weaker investment in privacy-preserving infrastructure. Smaller organizations feel them most because they cannot run several legal architectures at once. Rights can suffer too. If every layer appears responsible for everything, it becomes harder to see who holds an identity key, who can change an outcome, who must answer to the person. The Omnibus must simply simplify trigger logic and preserve responsibility where power is actually real. Let's return to Project Atlas. A coherent route begins at the device. Security, authentication, and bounded service measurements sit within a low-risk whitelist. Cross-service tracking still needs consent. A reusable preference signal avoids asking the same question on every single visit. The downstream GDPR question comes next and remains separate. The hospitals can identify patients, so they must use a lawful research route and the additional protection required for health data. Operative European rules should clarify compatible secondary use and carry common and minimum safeguards across borders. Inside the controlled data space, researchers are assessed on their own realistic means. Key separation, access controls, monitoring, and output review support that conclusion. A documented assurance record should be reusable across EHDS processes with reassessment if access or technology changes. If researchers later train an AI model, the same classification starts the analysis, while the AI Act governs lifecycle risk. This is no free pass. Each safeguard addresses its proper risk. 4 gates now form one sequence. Protect the device, authorize research, identify who can identify, then apply data space rules coherently. The Omnibus can reduce friction without reducing protection. One question remains. Who should write these practical boundaries? The legislator? The commission? Or supervisory bodies? That is the subject of the final lecture. I encourage you to continue to Lecture 5, Who Writes the Rules? I will ask which choices belong in legislation, which in guidance, and how Europe can make expert supervision accountable. Please watch my final lecture and the full series.